Next on the agenda is agenda item number 25. Discussion and possible action regarding Assembly Bill 489 from Bonta, Healthcare Professions, Deceptive Terms or Letters, Artificial Intelligence. Roseanne, can you provide us with the update?
Yes. So this bill proposes prohibiting a person or entity who develops or deploys an AI or generative AI system from having that system represent or imply that it is a licensed healthcare provider by using prohibited terms, letters, or phrases. It makes violations subject to the jurisdiction of the applicable licensing board. So this is that bill that we were referring to earlier that would give DCA boards some jurisdiction over actual companies rather than just individuals who are practicing. So currently under the DCA laws, unlicensed practice is a violation of any of the practice acts, and it's an infraction punishable by a fine. DCA boards are provided the authority to establish a system for the issuance of an administrative citation for unlicensed practice. DCA boards, with the approval of the director, are authorized to file a petition with the Superior Court of a county where a person has engaged or is about to engage in a violation of the law. And they can also, the Superior Court can issue an injunction or order restraining the conduct. The executive officer of any given board, or of this board, is permitted to issue citations and fines of up to $5,000 for unlicensed practice. And that's separate from or in addition to any other criminal or civil remedies. And then there's specific definitions of artificial intelligence and general artificial intelligence that I've cited here, which are used referred to in this bill. So this bill, as I said, would allow a board to take action against a person or entity who develops or deploys an AI system or generative AI system to imply that it's a licensed practitioner. Each use of a prohibited term or a letter is considered a separate violation. And the licensing board has jurisdiction to pursue an injunction or restraining order as a means of enforcement. The board currently has authority to take enforcement action against an individual for licensed practice, but as I said, we do not have authority to take action against a business. For an unlicensed practice, currently the disciplinary action would be a citation or a fine against a person. In terms of fiscal impact, this kind of references back to what John was saying earlier. We really don't know the scope of how frequently this provision would be violated. It could be something where once all the major companies got it, got to the understanding that you can't be impersonating a licensee, they might do it, or it could lead to a large number of violations. So we really don't know the scope of what is going to happen. If there were a number of these complaints, there would likely be a fiscal impact, and we would need additional budget for the Division of Investigation, Division of Department of Justice, and also probably more enforcement analysts to process the workload. There's a related bill that we're also going to be talking about today that would create a mental health and artificial intelligence work group. So we'll be talking about that separately, but it's related. Staff recommends that the board consider taking a support position on this bill. It appears to be a good start in the right direction, although of course there's much more to be done. So with that, I'll turn it over for discussion.
Thank you, Roseanne. That was great. Do we have any comments or discussion from the board? Kelly.
So I'd like to give an example of what I was talking about earlier. This is a website that says AI therapy in your pocket. Experience round-the-clock support and guidance with a 24/7 AI therapist. And then it goes into types of therapy, including psychodynamic therapy, cognitive behavioral therapy, dialectical behavior therapy, and Gestalt therapy. If you click on those sections, it says it goes into depth what psychodynamic therapy is. It's clearly advertising therapy. If you go all the way down to the bottom of the web page, in teeny tiny letters, it says assistant is not a licensed mental health therapist, psychologist, or psychiatrist. It's clearly advertising unlawful practice of therapy because it's not a person, it's an AI bot. This is exactly the sort of thing that is being marketed right now to youth and to consumers. It's not safe in any way, shape, or form. And this is just one example that I found on Google, right? I mean, this is being marketed right now. And I get that we need more research on it, but we also have a duty to protect consumers. I understand this is going to be a resource-laden operation. And I also understand that it's going to increase the workload of BBS, but we have a mandate to protect California consumers. We got to start somewhere. This sort of stuff can't be going on. It caters to young people who don't know a lot about the regulations related to mental health and therapy. A young person who's like 17 or 18 isn't going to go online and think, well, I should go to the Board of Behavioral Sciences and look up regulations and see who I can go to. They're not going to do that. They're going to download an AI app, which is advertising therapy. So I am certainly in support of this.
Wendy?
I have a question for Roseanne, though. In that example, would this bill actually address that? Because is this bill really only applying to AI that is pretending to be a person? So this says AI therapy. So it doesn't say this is therapy by a person. So would this bill even preclude what he found?
It would, hang on. It would allow us to take action if they were basically, so let me look at the exact wording. It's basically if they are using terms, I'm a marriage and family therapist. I'm a licensed mental health professional. And they're not actually a licensed mental health professional. It wouldn't, if they're not saying that and they're doing therapy, it wouldn't qualify there. But if they're purporting to be a licensed professional doing therapy, then we would be able to take action.
Okay, so this bill does not address that issue because it's not calling itself a person. So while I think this is a good step and a support, I mean, should we request amendments that it goes a little bit further to require disclosures even from, AI designated therapy? I mean, should it go even further than that? Because
Oh, I agree. I think it should go further than that. But I note in the example I'm looking at, it does say a 24/7 AI therapist. So it probably would fall within the regulation. At the very least, it might be, the interpretation of the regulation would occur in the courts. And I imagine a court would interpret this as falling within the regulation. But I agree with Board Member Strack. It should go further. Certainly when you have sort of a manipulative advertising such as this, which is clearly marketing it itself as therapy by a therapist.
yeah, because the bill itself, I think, let me see if I can, because it says the technology is being provided by a natural person in possession of an appropriate license. So it never says I'm a person.
So maybe this is step one? Or do we, take a support position, but then direct staff to say, go harder at it?
I think they've been doing a lot. We've worked with the author on kind of some of the beginning discussions, and they've been working, I think, with their legislative council to try to really get something developed that will stand up. I don't know if they're willing to take that next step yet, or what they're being advised legally. I think that to get it to this point, this is a first step.
Okay.
So could we do like a motion to support, and then maybe you just kind of bring up examples of like what Kelsey I'm just making up new names today. What Kelly said, or the example that he provided of, where it's clearly representing itself as AI, but it's still not therapy. So
Yeah, we can do that.
just see if there's an openness to the conversation, but I don't think we want to derail this bill to at least get something on.
Right.
I agree. And I would second Ms. Strack's
It was a messy motion. but
motion. Yeah, I'd
It
second.
was messy, but.
So
thank you.
basically to bring up that there is AI doing therapy as AI openly, but they're still doing therapy, and that's also a problem.
So then did I hear that we have a motion on the floor to support the bill? Okay, and we have a second. Okay, so the motion just needs to be to support. There we go. Any comments from our members in the audience? I don't know who did it.
Hello, Shanti Ezrin with CAMPT. Roseanne, thank you so much for the detailed overview of the bill here, AB 489. Wanted to share that CAMPT is also in support of this bill, which seeks to ensure transparency and accountability in the use of AI within the healthcare system. We believe that this bill will prohibit AI systems from falsely representing themselves as licensed healthcare professionals, and also believe it is important that patients know whether the information they receive is coming from a licensed healthcare professional or an AI system. So for those reasons, we support the bill.
Thank you, Shanti. Any comments from our remote participants?
We are open for public comment via WebEx. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users, dial *3 to raise your hand. And as a reminder to our mobile device users, you may need to hit the ellipses button, that's the ... in order to find your hand. Our first request comes from Ben Caldwell. Hold on just a moment, please. We're sending you a request to unmute your microphone.
I'll just be very brief and say that I am in line with the comments from board members and from Shanti from CAMPT. This is an imperfect bill, but it's a good place to start, and I would encourage your support. Thank you.
Thank you, Ben.
And that was our only request via WebEx.
All right, thank you. Abigail?
I just want to be clear that, so what we're suggesting is that it's not just that they're impersonating as a therapist, but that they're implying, right? Like using language that implies that they're licensed, right? Or can provide this level of service, and that there are like terms that they shall not use, right? Like therapy, right? Counseling, psychotherapy, that it be specific, like the terms that should not be used.
They can't necessarily be specific about the terms because this is blanket for all healing arts. But it's basically going back to the advertising regulations, and our advertising regulations do show those terms. That's why you see the vague language in the bill, is because it's a blanket capturing other professions as well.
Got it. Okay, good. Thank you.
Any further comments from the board? Susan?
I just have a question for Roseanne. Obviously, Representative Bonta is very interested in this subject. So I'm curious how you operate. I mean, do you know whether he's also offering a bill that says a business as opposed to an individual?
I'm not clear exactly what your question is. I mean, this is the bill that they have on the table this year. There's other bills related to AI, and this one that touch on other things. This one specifically touches on use in healthcare professions.
Right, but what I'm saying is it's clear that Bonta is very interested in this very subject. And I'm wondering if he has a bill, or you've talked to his person and his person who deals with this subject, whether he's planning to offer a bill that also talks about holding a business, how a business would be held responsible as opposed to an individual.
So this particular bill would allow a business to be held responsible. It allows us to take action against somebody who basically owns the business or the business itself. I don't know about what her other plans are to run future legislation. They haven't gone into that.
And that's something, I mean, as we discuss, you know, what we're talking about here, as we discuss with the office, we might learn some more stuff that they're looking at and maybe wanting to pursue later on. So yeah, we'll keep our ears open.
All right, thank you. Christina, would you take the vote, please?
So just to be clear, it's to support AB 489.
To
correct?
support, yes.
And that was motioned by,
Wendy, seconded by Kelly,
thank you.
in a roundabout sort of way, but we got there.
Okay. Eleanor Uribe,
Yes.
Abigail Ortega,
Yes.
John Sovek,
Yes.
Chris Jones.
Yes.
Wendy Strack,
Yes.
Kelly Ranasigi,
Yes.
Susan Friedman, Justin Huft.
Yes.
Motion carries.
Wonderful. And then Roseanne, we would direct staff to continue having conversations about the evolution of
Yes.
the bill. Thank you.
We'll continue having conversations with the author's office.
Wonderful. All right. Next on the agenda is item number 26, discussion and possible action regarding Assembly Bill 742, LOARI, Department of Consumer Affairs licensing applicants who are descendants of slaves. Roseanne, would you give us an
Yes.
update?
Thanks, Chris. So this bill would require boards within DCA to prioritize applicants seeking licensure if they are certified by the State Bureau for Descendants of American Slavery as a descendant of American slaves. So currently, under existing law, the boards under DCA have various provisions allowing expedition of certain of the license types for certain types of applicants. That includes discharged members of the U.S. Armed Forces, military spouses, individuals who have been admitted to the U.S. as a refugee or have been granted asylum or who hold a special immigrant visa. There's a few specific to other boards that allow expediting for other reasons, but pretty much the ones for asylum or for military service are across all boards. This particular bill would require boards under DCA to prioritize if somebody prioritize applicants if they are a descendant of American slaves. The bill is contingent on another bill becoming enacted, and that's SB 518. That bill currently proposes the establishment of the Bureau for Descendants of American Slavery. And the effective date of this bill would commence once that Bureau establishes a process to just certify descendants of American slaves. And then the bill includes a sunset date of 4 years from the operative date or January 1, 2032, whichever is earlier. And just a brief overview of SB 518, which is the companion bill to this. That bill establishes that bureau that I just mentioned under the California or within the California Department of Justice. It tasks that bureau with determining how an individual's status as a descendant will be confirmed and establishes a process to certify descendants. Proof of the status is then qualifying criterion for benefits authorized by the state for descendants. And it defines descendants as descendants of African-American chattel enslaved persons in the United States or descendants of a free Black person living in the United States prior to the end of the 19th century. So that's what's running kind of parallel to this in SB 518. The author's office highlights in its intent of this bill and their intent of this bill that descendants of slaves have historically faced barriers to accessing licensing due to the longstanding impact of racial bias. And so they are seeking to rectify a process where they have historically been overlooked and underrepresented. In terms of the impact this bill requires the board to prioritize these applicants. The meaning of prioritize is not specified and probably should be clarified. And I believe that there's an ask in the legislature right now, or it was mentioned in the most recent analysis that they were discussing that they should clarify that. Staff assumes that the intended meaning of is that these applicants will be expedited. On average, the board processes about 17,000 applications annually, assuming maybe 3% of applicants would qualify. It would be about 500 applicants a year. A separate state bureau would be making that determination based on very specific criteria. So the staff believes that the increased workload from this bill is minor and absorbable within existing resources. This bill is very similar to a bill that the board took a supportive amended position on last year. It proposed requiring boards within DCA to prioritize applications from African American applicants, especially those descended from a person enslaved in the United States. And so this is this year's effort to continue that legislation. Staff is recommending a support position on this bill. So I'll open it up for discussion.
I have a question with regards, and it's a general question with regards to expediting applications. Is there some sort of like order that they're expedited in, or is there just an expedited line? Like if you meet military, criteria, whatever, do they just go into a different line?
I believe
what I
it's
mean.
just, Steve, it's just they're just expedited. We don't expedite based on the type of expedite. It's
Okay,
just-
so
you're
it's just one
expedited.
line for all the expedited people. Okay. All right. Any other comments or questions from the board? No?
I'd like to motion to support this.
All right. Justin motions to support. Do we have a second?
I'll second.
All right. Wendy seconds. Any comments from our audience?
Hello again, Shanti Ezrin with CAMPS. As always, Roseanne, thank you so much for the overview of the bill. So there were a handful of prioritization bills last year, and CAMPS has looked at each one and assessed each one, and that includes this bill as well, AB 742. So while we support ways or finding ways to help providers get through the application process, we typically take a neutral position on these types of bills, just given the current processing delays and potential unintended consequences that it may have on processing timelines. Thank you.
Thank you, Shanti. Any comments from our remote participants?
Now is the time to raise your hand on agenda item 26 and the motion. If you'd like to make a comment, please tap that hand button at the bottom of the screen. Dial-in users, dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue with the... Oh, hold on. We have a hand. Dr. Jasmine Smith, we are sending you a request to unmute your microphone.
Hi, thank you. I just wanted to get clarity. I believe the previous discussion was that there was one singular process for the expedited reviews. And I know that there was a recent comment from CAMP on whether or not this would add a delay. So I just wanted clarification on if that is accurate.
So there is, we have basically all the expedite licenses get kind of sorted out and processed separately. We don't have a process that sorts them out based on the type of expedite. So it really just, whether there would be a delay, it really depends on how many expedites we get. We still have, a finite number of staff. So we'll do our best to expedite things as quickly as possible, not have it impact other workload. But, if we get 1,000 expedite applications in a month, the timing will be affected versus if there's only 2 or 3.
And that's something that we would look at later on too. If for some reason, right now, really our expedites are very low, the amount we get, and we do process by date order. So if an expedite comes in on that date, that will get pushed forward to the next business date that we're processing. But it is such a low volume right now. The impact is, I think, like we said, pretty minimal. But if for some reason that's changed, we'll definitely look to seek possibly additional resources for that.
It does kind of depend. I mean, last year there was kind of a pushback from the governor on all of these expedite bills because eventually, yes, if we have 8 different bills to expedite based on 8 different things, and then we have to expedite, eventually nobody's getting expedited if everybody
Back to normal, yeah.
qualifies for an expedite. But I don't, it just depends on how, what gets us to that point, and we would have to monitor that on a workload basis.
Thank you.
And those were all of our requests via WebEx.
Excellent. Thank you, moderator. Abigail?
I see on the opposition, the California Landscape Contractors Association opposes, and the Pacific Legal Foundation. Is there like any reasons that we know of that the landscapers care about this bill?
I don't know the specific reasons why they have sent, that means that basically they've sent the committee an opposition letter. There might be, I think the Pacific Legal Foundation had a write-up in the, one of the committee analysis that it felt like it might not survive a constitutional challenge. So there's those kind of arguments. I can't speak specific, that's probably where the legal foundation is was more of a legal technical argument. I can't speak to why the Contractors Association was opposing it.
Okay.
Further comments? All right. Christine, would you take the vote, please?
Eleanor Uribe,
Yes.
Abigail Ortega,
Yes.
John Sovek,
Yes.
Chris Jones,
Yes.
Wendy Strack,
Yes.
Kelly Ronasinghe,
Yes.
Susan Friedman, Justin Huft.
Yes.
Motion carries.
Thank you, Christina. All right, next on the agenda, item number 27, discussion and possible action regarding Senate Bill 470, Laird, the Bagley-Keene Open Meeting Act, and teleconferencing. Roseanne?
So this bill continues the modernization of the Bagley-Keene Open Meeting Act that was established by SB 544 in 2023. That bill provided 2 new teleconference meeting options for state bodies to hold public meetings that are set to sunset on January 1, 2026. So this bill would basically extend the sunset date for the 2 options until January 1, 2030. So we have this board is subject to the Bagley-Keene Open Meeting Act. It used to be that there was only one option. Pre-COVID, there was only one option for a teleconference meeting. And that was basically that the address of every teleconference location had to be noticed in the meeting agenda and the net meeting notice, and that each teleconference location had to be accessible to the public. So if a board member was participating in a teleconference meeting from their house, then they would need to make their house address available on the agenda, and they would have to make that location accessible to any public that wanted to show up. And so that was kind of there's various concerns with doing that, and people not wanting their address disclosed. There's ADA considerations for access, things like that. So once the COVID hit, the governor issued some temporary waivers for that. So we had meetings other ways. And then in 2023, the bill ran SB 544 that allowed a couple of different options. That one of the options requires the open portion of a teleconference meeting to be visible and audible to the public at each location. The state body needs to provide a way for the public to remotely hear, observe, and address or attend the meeting through a number or a website or other platform. And it requires at least one member of the state body to be physically present at each location. However, a majority of the members of the state body have to be physically present at the same location, but aside from a majority, there can be other people, other members teleconferencing. at the remote location. And in exchange for that sort of compromise, a remote location is not required to be accessible to the public, and it does not need to be disclosed. So it allowed a way for some board members to be able to join via teleconference, although not all. And there would be one designated spot and link where the public could participate. There was also another allowance for state advisory boards, which was basically applies to the board's committees, where the advisory body can participate, members can participate remotely, and the remote locations don't need to be disclosed. But the meeting must have a designated primary physical meeting location. And members of the public must be able to physically attend there, and at least one staff member must be present there. And the state body must provide an equivalent means for the public to hear or observe the remote meeting remotely. So basically, the board has been using that option to conduct our committee meetings. The staff is generally in a hearing room or a meeting room, and then we have the members attending via teleconference, and the public has a platform to attend either in person or via teleconference via WebEx link. So basically, those two newer provisions sunset on January 1, 2026, and this particular bill would move that sunset date until January 1, 2030. The author is running this bill. He believes the new provisions promote ongoing equity and public and disability access in state board and commission meetings. The board has been utilizing both of these hybrid versions of the Bagley-Keene Act, and it has seemed to help increase meeting participation by having that web link. The hybrid format allows board members to attend meetings remotely when necessary, ensuring that meetings can proceed even in situations where in-person attendance might otherwise prevent a quorum. It's been particularly beneficial in instances where quorum was at risk, and enables us to continue to have the meeting. We have 3 advisory committees right now, and all board members, like as I said, participate remotely in committee meetings. This arrangement increases the likelihood of participation by allowing members to attend without disrupting their regular work schedules or spending time traveling to Sacramento for just a 3 to 4 hour half-day meeting. It also can reduce travel-related costs for the committee meetings. With respect to public participation, offering both in-person and virtual meeting options via WebEx has seemed to lead to increased engagement. Many stakeholders with full-time jobs face barriers to attending in person due to time and also travel cost constraints. And virtual participation provides a way for them to participate if they choose to do so. So that is this bill, and I'll open it up for discussion.
Comments or questions? No? All right. Do we have a motion?
Chair, I'll move to support.
All right. Do we have a second?
John Sovek, second.
Excellent. Any comments from our participants in the audience? Any comments from our remote participants?
We are open for public comment on agenda item 27. This is Bill 470. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users, dial *3 to raise your hand, and we will call on people in the order we have requests. We're going to take a few seconds now to see if we have a request for public comment. Seeing no request, you wish to continue with the motion?
Yes, thank you, moderator. Any further discussion? All right, Christina, please take the vote.
I will start with you, Justin Huft,
Yes.
Susan Friedman, Kelly Ronasinghe,
Yes.
Wendy Strack,
Yes.
Chris Jones,
Yes.
John Sovek,
Yes.
Abigail Ortega,
Yes.
Eleanor Uribe.
Yes.
Motion carries.
All right, thank you. Next on the agenda, item number 28, discussion and possible action regarding Senate Bill 497, Weiner, legally protected healthcare activity. Roseanne?
This bill seeks to protect the privacy and safety of individuals seeking gender-affirming health care and mental health care in California, as well as the healthcare providers who deliver these services by strengthening protections in law related to the sharing of their healthcare information. So under existing law, there's a definition of gender-affirming mental health care as mental or behavioral health care that respects the gender identity of the patient as experienced and defined by the patient. Current law prohibits a health provider, health service planner, contractor from disclosing medical information regarding a patient without first obtaining authorization, except under certain specific circumstances. Current law also prohibits a healthcare provider, healthcare planner, contractor from releasing medical information related to a person or entity allowing a child to receive gender-affirming healthcare or mental health care in response to a civil action based on another state's law authorizing a civil action to be brought against a person or entity allowing a child to receive gender-affirming healthcare or gender-affirming mental health care. Healthcare providers and service plans are prohibited from releasing medical information to persons or entities who have requested it and who are otherwise authorized by law to receive it if the information is related to a person or entity allowing a child to receive gender-affirming health care or mental health care if it's being requested pursuant to another state's law that authorizes a person to bring civil action for the providing or allowing a child to receive this for civil action for allowing a child to receive this care. Current law also specifies a process for requesting the issuance of a subpoena in California based on a foreign, or what that means is an out-of-state subpoena. The law prohibits issuance of a subpoena if the foreign subpoena is based on violation of laws in another state that interfere with a person's right to allow a child to receive gender-affirming health care or mental health care. So this bill is amending the law right now. In these certain instances, there's the law prohibits these kind of actions based on a violation in another state where somebody's allowing a child to receive gender-affirming health care. In general, what's being done here is they're trying to expand that a little bit. So it also protects an individual seeking or obtaining gender-affirming health care or mental health care, not just necessarily a child. So there's a little bit of an expansion here of what healthcare providers can't provide. It does not prohibit the compliance with an investigation or activity that is punishable as a crime in California. It's targeting basically the other states' healthcare laws that are allowing people to take action when gender-affirming healthcare is received in this state. It also prohibits a California licensed attorney from issuing a subpoena if the foreign subpoena is based on a violation of another state's laws that interfere with the person's right to seek gender-affirming healthcare or gender-affirming mental health care. So basically, in terms of the author's intent, they are seeking to protect the privacy and safety of these individuals seeking gender-affirming health care in California by protecting their sensitive data from being disclosed by out-of-state law enforcement to prosecute people for receiving care that's legal in California. And then previous legislation, this is basically building on a law that was run in 2022, SB 107, so a few years ago, that began putting these safeguards in California law to support individuals seeking gender-affirming care here. So staff recommends a support position on this bill.
Comments? All right, do we have a motion?
John Sovak, motion to support the bill.
Justin Huft, second.
All right. Any comments from our participants in the audience?
Shanti Ezrin with CAMT. Roseanne, thank you again for your overview and analysis of the bill. Wanted to share that CAMT is also in support of AB 497, which strengthens California's commitment to protecting the privacy and safety of those seeking gender-affirming care. The bill also takes steps to safeguard sensitive medical information by requiring out-of-state law enforcement to require a warrant before accessing that data. It makes sure that patients and also providers are not exposed to legal risks from hostile laws in other states. We believe that it's critical that California continues to ensure confidential medical treatments to all Californians, and that is why we support the bill.
Thank you, Shanti. Any comments from our remote participants?
We are open for public comment via WebEx on the motion for Agenda Item 28, Senate Bill 497. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users dial *3 to raise your hand, and we will call on people in the order we have requests. And it looks like our first request is coming from Ben Caldwell. Hold on just a moment, please. We're sending you a request to unmute your microphone.
Thank you very much. Good afternoon, Ben Caldwell, MFT. This bill does seem worthy of support. I would second what Shanti from CAMT said. I do have a question. I don't know, maybe Roseanne, this is best directed to you. This is kind of at the outer edges of my ability to read some of the technical stuff in these bills. Can you comment on how this is different from or maybe expands upon what was in Assembly Bill 352 in 2023? That seems to touch many very sort of closely linked areas of law with many similar kinds of protections. And I'm having trouble understanding what is the addition here, or what is the change that this particular bill would make. Certainly, I'm supportive regardless. I just want to have a better technical understanding. Thank you.
Without looking at that particular bill, I can't comment on it right now. It's directly linked to SB 107 in 2022, which basically put these safeguards in place for care provided to minors. And this is taking the additional step of applying them to all people, but I can't, without taking a look at that bill, I can't comment on it right now.
Thank you.
Love you guys.
And that was our only request online.
All right, thank you, moderator. Any further comments from the board? All right, Christina, please take the vote.
Justin Huft,
Yes.
Susan Friedman,
Oh, Susan,
Susan?
your
Susan?
microphone.
Susan?
Your microphone.
Yes.
thank you. Kelly Ronasinghe,
Yes.
Wendy Strack,
Yes.
Chris Jones,
Yes.
John Sovek,
Yes.
Abigail Ortega,
Yes.
Eleanor Uribe.
Abstain.
Motion carries.
All right, thank you. Next item on the agenda, item number 29, discussion and possible action regarding Senate Bill 579 Padilla, Mental Health and Artificial Intelligence Working Group. Roseanne?
So this is the second of the AI bills that I was talking about earlier. This particular bill would require the state government operations agency to appoint a mental health and artificial intelligence working group by July 1, 2026 to examine the role of AI in mental health treatment. So under current law, the government operations agency is within state government, and the state departments that comprise it are the Department of General Services, the Department of Technology, and the Office of Data and Innovation. And so this bill would require that agency to appoint this working group by July 1, 2026. It would be tasked with evaluating several things: the role of AI in improving mental health outcomes, ensuring ethical standards, and addressing concerns about AI in mental health settings. It would discuss current and emerging AI technologies, potential risks associated with AI to mental health. It prescribes that the 15-member working group consists of specified people. It would be 4 behavioral health professionals, 3 AI and technology experts, 2 persons with a background in patient advocacy, the Director of Healthcare Services, a member of the Senate, and a member of the Assembly, so a pretty broad working group. The working group is required to take input from a broad range of stakeholders and conduct at least 3 public meetings to incorporate feedback. And then it would be required to issue a report to the legislature by July 1, 2028 on the potential uses, risks, and benefits of using AI technology in mental health treatment, including best practices and recommendations for policy around facilitating beneficial uses and mitigating risks, establishing a framework for training mental health professionals to enhance their understanding and incorporation of AI tools into their practice. And then the working group would issue a follow-up report by January 1, 2030 on the implementation of the working group's recommendations. The working group would be subject to the Bagley-Keene and Open Meeting Act, so all meetings would be public subject to that act. The author's office is relaying a desire to ensure that there are proper guardrails in place so that AI is incorporated into mental health treatment in a thoughtful and safe way. The bill is currently being sponsored by CAMPT and the California Psychological Association, and staff is recommending a support position on the bill.
Thank you, Roseanne. Susan.
I move that we support SB 579 at the moment by Senator Padilla.
You want to have any discussion first, or you just want to go right to support? Do we have a second? You want to discuss before there's a second?
We can discuss after the motion too, right?
Yeah,
Support. I second the motion.
second? Okay, excellent. Any discussion? All right, any discussion from our participants in the audience? I know, I was just going to say, you can just have that seat, Sean. He gets good steps in.
Thank you so much. Shanti Ezrin with CAMP. Roseanne, thank you as always. Like you said, we're very proud to co-sponsor this bill along with the California Psychological Association. I can kind of go into more details about the bill, but I think Roseanne did a really great job in covering it. This is essentially a bill that would establish a mental health and AI working group to evaluate the role of AI, particularly in a couple different areas to improve mental health outcomes, really ensure ethical standards, explore technology in diagnosing and treating mental health concerns, and also identify risks with AI in mental health. So as everyone here already knows, AI technology continues to expand, and we also know that there are some mental health professionals who are already utilizing AI in their note-taking and some other administrative tasks. However, there are also many concerns with how AI is being utilized, such as companies that have begun to create AI chatbots marketed as digital therapists. There's been a lot of conversation today around AI, which is great. This is a bill that will really help ensure that we take a leadership role in responsibly integrating AI into mental health care while safeguarding patient well-being and safety. So for those reasons, again, we're very proud to co-sponsor the bill. Thank you for the motion, and we would ask for the board to support the bill.
All right, thank you. Any comments from our remote participants? Moderator?
My apologies. I was on mute. We are open for public comment via WebEx. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users, dial *3, and mobile device users, you may need to hit the ellipses button. That's the ... Our first comment's coming from Ben Caldwell. Hold on just a second. We're sending you a request to unmute your microphone.
Thank you, Ben Caldwell, MFT. As you all know, the rapid development of AI systems in mental health care raises a number of really important regulatory and public safety concerns. AI therapists, and yes, there are many that call themselves that, have already conducted millions of interactions with U.S. consumers, so this is not a distant future concern. The work group approach that's proposed here will help ensure that policy responses to AI will be thoughtful and well-informed, and I'm happy to encourage a position of support. Thank you.
Thank you, Ben.
And that was our only request via WebEx.
Thank you, moderator. Any further comments? All right, Christina, please take the vote.
Justin Huff,
Yes.
Susan Friedman,
Yes.
Kelly Ronasinghe,
Yes.
Wendy Strack,
Yes.
Chris Jones,
Yes.
John Sovek,
Yes.
Abigail Ortega,
Yes.
Eleanor Uribe.
Yes.
Motion carries.
Thank you. Next on the agenda, item number 30, this is the discussion and possible action regarding Senate Bill 641, Ashby, Department of Consumer Affairs and Department of Real Estate, States of Emergency Waivers and Exemptions. Roseanne?
Yes, this bill would permit boards under DCA and also the Department of Real Estate to waive certain specified provisions of their licensing laws for licensees and applicants who are affected by a declared federal, state, or local emergency. So existing law already defines 3 types of emergencies. It defines a state of emergency, a local emergency, and a state of war emergency. It also allows state agencies that issue business licenses, including licensing boards under DCA, to establish a process to apply for a reduction or waiver of any fees required to obtain or renew it or activate a license or replace a license for persons or businesses that have been displaced or experiencing economic hardships because of an emergency. The California Board of Pharmacy has a law that permits it to waive provisions of its Practice Act or corresponding regulations during a declared federal, state, or local emergency, if in the board's opinion, the waiver will aid in the protection of public health or the provision of patient care. The Board of Pharmacy may elect to continue such waivers up to 90 days from the termination of the declared emergency if in its opinion, the continued waiver will aid the protection of public health or the provision of patient care. Currently, under current law, all applicants, registrants, or licensees of the Board of Behavioral Sciences who have an email address must provide the board with that email address, and they must notify the board of any changes to it within 30 calendar days. The law specifies that email addresses are provided to the board are confidential and not subject to public disclosure. So that's kind of a framework of the existing laws that are out there. This particular bill would allow DCA boards that are to waive certain provisions of law for applicants or licensees impacted by a declared federal, state, or local emergency, or if their home or business is in a disaster area, and it specifies what provisions those of the law may be waived. So that's exam eligibility and timing requirements, licensure renewal deadlines, CE completion deadlines, fee submission timing requirements, and delinquency fees. It provides that any such waiver extends through the duration of the declared emergency or disaster, and a board may decide to extend it for either 1 year after the end of the declared emergency or disaster, or for an additional period beyond 1 year after that end. The bill requires DCA boards to waive the fee charged for processing and issuance of a duplicate copy of a license for someone who's impacted by one of these emergencies, or if their home or business address is. And it exempts licensees or registrants whose home or business mailing address is in a declared emergency from the requirements to notify the board to change their mailing address within 30 days. This bill also requires all applicants and licensees to provide the board with an email address. The author states that the intent is to help professionals maintain their licensure status during times of disaster, which can ensure that they can continue to work without facing administrative burdens. So most DCA licensing boards do not currently have the authority to issue their own law waivers. During the COVID pandemic, the governor declared a state of emergency and issued an executive order that permitted the director of DCA to waive any statutory or regulatory professional licensing requirements pertaining to healing arts. The director granted several waivers pertaining to the board's licensees and registrants. There was a waiver of in-person supervision requirements. There was an extension of exam eligibility periods. And there was a waiver that was regarding LMFT trainee practicum enrollment requirements. Recently, due to the LA wildfires, the governor issued an executive order that postponed license renewal fees for 1 year for DCA licensees whose residents or businesses are within one of several specified zip codes that were impacted by the wildfires. This bill is an urgency measure, meaning that it requires a 2/3 approval vote of the legislature, and if signed, it becomes effective immediately. So some questions regarding this bill. It's unclear exactly how board staff would confirm the existence of a declared emergency. There's definitely some types of emergencies that are different in scope and scale than others. Would there be an official government notice to be provided to DCA, or would staff be responsible for confirming all declared emergencies? If staff must confirm, we might need an additional position to confirm and advise the board of the scale of their request. The bill grants the board the authority to waive provisions of law related to exam eligibility, renewal deadline, and fees. This doesn't necessarily cover all aspects of the board's licensing requirements. For example, during COVID, the board obtained waivers to in-person supervision requirements and practicum requirements. Those don't appear to be covered under the waiver authority granted under this bill. The board already has an existing email requirement that's more descriptive than the one in this bill. This bill requires everyone to provide the board with an email address. Our current our current language only states that they have to provide their email address if they have one. In terms of the impact to the board has the discretion on whether to grant a waiver in a declared emergency. If the board doesn't take action, then there's no waiver to be granted. To elect to waive a provision of the law, it appears the board would be required to take formal action. So the board may need to call additional meetings if a state of an emergency happens in between board meetings. This could result in additional costs, travel, site rental, costs for board member pay, and per diem. It's unknown the frequency of the states of emergency it's not unknown how frequently states of emergency would rise to the level of law waivers being needed in any given year, so we can't really estimate those costs. It's also unknown how the board would receive confirmation that there's a declared emergency, especially for smaller scale emergencies that take place at a local level. How would we know that there's a declared emergency that's directly affecting, and what is the way that we measure or compare which ones, what threshold requires the board to act in any given situation. So we might need more resources or criteria to make that kind of a determination. In terms of lost fee revenue, we don't really anticipate that there would be a wide fee revenue loss unless there was a large scale emergency, in which case that's possible. But that sort of remains to be seen. There are potential breeze costs to this bill, depending on the waivers implemented. For example, modifiers or other breeze changes may be needed. It sounds like there's a lot to be worked out with this bill as it's still going through the committee process. So staff recommends a watch position on this bill at this time.
Any comments, board? Do we have a motion? Do we motion to watch it? No.
Not to watch.
Sorry about that. No, that makes sense. Not to watch, yeah. We'll just keep an eye on things. Any comments from our in-person participants? All right. How about from our remote participants?
We are open for public comment via WebEx on agenda item 30, and this is Senate Bill 641. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Dial-in users, dial *3, and we will call on people in the order we have requests. And it looks like we're not going to get any takers on this one.
All right, so we will continue. Thank you, moderator. We will continue to watch this bill. Thank you, Roseanne. All right, moving on. Next is item 31, a discussion and possible action regarding Senate Bill 775, Ashby, Board of Behavioral Sciences. Roseanne?
Yes, so this is the sunset bill for the Board of Psychology and also our board, the Board of Behavioral Sciences. It would extend this board's sunset date until January 1, 2030. And this bill also contains several amendments that the board is sponsoring this year. DCA and the BMP committees asked this year that in lieu of running our own bill, that we include provisions we would like to run in the sunset bill. So that is included in SB 775. So in terms of the sunset piece of the bill, existing law provides for the licensure of regulation of the board's practitioners until January 1, 2026. And then it also specifies that the board has the authority to employ an executive officer until January 1, 2026. So those are the sunset provisions that the board and the bill is proposing to extend those, like I said, till January 1, 2030. This bill also includes or will include special, it has other amendments sponsored by the author. It officially names the LMFT Practice Act, the Marriage and Family Therapy Practice Act. It's slightly different from what it's named right now. There's some changes to referencing the Clinical Social Work Practice Act instead of referencing social work licensing law. And there's some technical amendments about a future repeal. What would happen if Section 4990, which is the sunset clause, were to be repealed? There's a technical amendment pulled out into a separate section. They're making some changes for a Board of Psychology as well that they've requested or the committee wants, in addition to extending their sunset date. So those are the author's amendments. And then separately, there are several amendments that are sponsored by the board or that will be in the bill that are sponsored by the board. We have some technical and non-substantive amendments. We're proposing to remove a duplicative enforcement statute in the LMFT Practice Act. We're looking to clarify the required supervision ratio for ASWs. We're making some clarifications regarding W-2 form requirements for applicants. It is expected that the bill will be amended soon to do the statutory amendments the board requested to potentially allow adoption of the AMFTRB national exam as the clinical exam in the future, if chosen, the board chooses to do that via regulations. It proposes to delete or extends the sunset dates for two provisions of the Board's Practice Act. That is the allowance of supervision via video conferencing. The bill proposes to delete the sunset date. Excuse me. And then the temporary practice allowance, the bill proposes to extend the sunset date to January 1, 2030. The bill makes changes to the licensing requirements for educational psychologists by specifying experience requirements in greater detail, clarifying experience requirements for in-state versus out-of-state school psychologists, and adding a age limit to the passing score on the LEP exam. And then the bill makes several amendments to the retired license statute that the board requested, permitting a license that has been expired for up to 3 years to be retired, which would remove a barrier that someone who had let their license expire from having to pay to reactivate it in order to simply retire it. We're clarifying the meaning of subject to disciplinary action for purposes of a retired license, specifying what information needs to be provided in a retired license application, specifying the professional title that a retired licensee is able to use. So those are some of the things that the board has requested in the bill. In terms of the sunset piece of the bill, the sunset review process was enacted by the legislature in 1994 through the Joint Legislative Sunset Review Committee. That committee was tasked with performing sunset reviews. It was built on an assumption that if a board is operating poorly and lesser measures have been ineffective in correcting the problems, the board should sunset. So all DCA boards undergo a sunset review after a set number of years, usually 4. Boards up for review submit a report to the Joint Committee, attend a hearing before the Joint Committee, and then respond to any recommendations of the Joint Committee. And then the committee determines whether the board should sunset or be extended for an additional period of years. The last time the board underwent sunset review was 2020 to 2021. It was a little bit weird that year because it was supposed to be 2020. We were in the middle of sunset and it was sort of delayed due to COVID. They pushed it out a year and then they did our sunset last time in 2021. And that's the time we were extended to January 1, 2026. So here we are now again. A couple of things I wanted to point out about this bill. Business and Professions Code Section 4980.04 is not currently being amended in the bill. It already cites that the bill, the Marriage and Family Practice Act, is to be called the Licensed Marriage and Family Therapist Act. This bill is making an amendment to Business and Professions Code 4980A to state that Chapter 13 of the Business and Professions Code is called the Marriage and Family Therapist Practice Act. Staff does not have a preference which exact citation is used or where it's located. However, we have let the committee know that there's some conflicting information there and that the name of the Practice Act should be consistent in all places with the law, in the law where it is cited. So we are working with the committee on that already. The bill also correctly changes the sunset date in Business and Professions Code Section 4990. However, there is also a sunset date in 4990.04 subsection F that was missed, which is the reference to employing an executive officer until, and then whatever the sunset date is. So we have relayed to the committee that also needs to be adjusted to include that section. In terms of the board sponsors amendments, the majority of the board sponsored amendments were amended into the bill last week. There were a few drafting errors in the language, and staff is in the process of working with the committee on corrections so that the language in the bill matches the board approved language, and that is expected soon. Additionally, the AMF-TRB, as I alluded to earlier, the AMF-TRB national exam is the clinical exam. Has not been included yet, although we have some indication that that's going to be included soon. Also, we have an indication from the committee that they have brought to us that the extension of the sunset date of the temporary practice allowance to 2030, they may also be asking for an amendment for greater oversight on the temporary practice allowance to have greater oversight of when somebody stops their temporary practice allowance. So stay tuned for that. They haven't asked anything specific yet, but they've indicated that they might have a request. So we'll wait for that and work with them on that. In terms of what action is needed today, the board is already the sponsor of the amendments that I discussed that the board has approved. So there's several board sponsored amendments in the bill that the board is already sponsoring and they don't need a position on, but there are portions of the bill that are being sponsored by the author or the Business and Professions Committee and Assembly Member or Senator Ashby. And the board should consider taking a support position on those amendments. Those amendments relate to extending the board's sunset date to January 1, 2030 in BPC 4990, and the board should also direct staff to work with the BPC committee to ensure that the sunset date is also added into section 4990.04 and that the LMFT License Types Practice Act is consistently named throughout the law. So with that, I'll open it up for comment.
Any comments or questions? All right, I will move that we support Senate Bill 775. We have a second?
I think I want to use more of the wording
Sorry,
of the recommendation. Do you want me to read it off?
Yeah, sure.
Okay. So if the motion would be to take the board supports the author sponsored amendments extending the board's sunset date to January 1, 2030 in BPC section 4990 and to also have the same sunset date added into 4990.04 and ensure that the LMFT License Types Practice Act is consistently named throughout. So basically support the sunset date and ask for those two technical bullet points.
So moved.
I'll second. Wendy Strack.
All right, thank you. Any further discussion? Any comments from Shanti? our participant.
Thank you so much, Shanti Ezrin with CAMT. Roseanne, thank you for covering all of the different pieces of this bill and the status of the different amendments for it. I'll share a couple of things based off of what you had covered. So on the titles of the acts, ideally it would be titled the Licensed Marriage and Family Therapist Act. So thank you for voicing that with the committee to make it consistent in law. And then thank you also for providing the update on the language being added to the bill that would allow for the adoption of the AMFTRB MFT National Exam via regulations. We are looking forward to seeing that amendment once it makes it into print and then proceeding to support the rest of the bill. Thank you.
All right, thank you. Moderator, any comments from our remote participants?
We are open for public comment on agenda item 31. This is Senate Bill 775. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. For our mobile device users, you may need to hit the ellipses button, that's the ... in order to find your hand. And our first request is coming from Leah Brew. Hold on just a moment. We're sending you a request to unmute your microphone.
Dr. Leah Brew, LPCC, and counselor educator. The only comment I have is when on the website where we look at all these items, instead of what Roseanne just read, it's the board meeting minutes from February 27th and 28th. And I would hope maybe Steve could put up the correct agenda item so I can go back and look at it if I wanted to.
Yeah, we can correct that post.
Thank
We're
you.
aware of that, and we have been trying to get that fixed over the last hour, but thank you for mentioning that so the
Much
public is aware.
Thank you.
And that was our only request via WebEx.
All right, thank you. Any further comments? All right, Christina, please take the vote.
Justin Huft,
Yes.
Susan Friedman,
Yes.
Kelly Ranasinghe,
Yes.
Wendy Strack,
Yes.
Chris Jones,
Yes.
John Sovek,
Yes.
Abigail Ortega,
Yes.
Eleanor Uribe.
Yes.
Motion carries.
All right, thank you. Are we doing okay? Or does anyone need a break? Or are
We're
we
pretty much done.
pretty much?
Yeah.
Then we will forge forward. All right, item number 33. Sorry. Update on the board. No, that's not right. Oh, no, 32 was taken off. I think the title is wrong on this one.
No, it's
Legislative update. So the legislative update is just SB 775. So I'm just going to defer to our previous conversation.
Okay,
That's the only legislative update that we have right now.
so we're good.
Good.
So we're moving on to 34. All right, sorry for the confusion. Item number 34, update on board rulemaking proposals. Christy, you get a turn.
Yes, thank you. So the disciplinary guidelines, which we discussed the comments today, so those are basically going to keep moving through the process. So there's a final review. I have to prepare some documents. They'll go through another DCA review, then they'll go over to OAL for final approval. The telehealth regulations, we did a notice of modified text that was approved at our last board meeting in February. That was mailed in April. Comment period ends May 5th. So if we get any additional comments, we'll bring them back. So far, I haven't seen any. The continuing education proposal, that has been submitted to the Department of Consumer Affairs for a review on April 8th. So that's going to take a little time, but I'm hoping to have that back. You know, it can take them a while depending on their workload. The advertising regulations, we had that hearing yesterday, so we'll keep moving through that process. And then the English as a second language additional examination time, we're still preparing the documents. And I know recently consulted with the budgets office on there may be is a little bit of a fiscal that goes with it. So that's taking a little bit of time, but we're going to working on keeping that one moving as well. And that's it.
All right, thank you, Chrissy. Any comments from the board? Any comments from Shanti? Any comments from our remote participants?
We are open for public comment via WebEx on agenda item 34. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Mobile device users, you may need to hit the ellipses button, that's the ... in order to find your hand. We're going to take just a few seconds now to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue with the agenda?
Yes, thank you, moderator. Next on the agenda are the suggestions for future agenda items. Do we have any future agenda item suggestions from our board members? No, from our participant. Do we have any suggestions from our online participants?
Now is the time to raise your hand if you'd like to make a suggestion for future agenda items. Please do so by tapping that hand button at the bottom of the screen. Mobile device users, hit the ... in order to find your hand. We're going to take a few more seconds to see if we have a request. And we have a request from Ben Caldwell. Hold on just a moment, please. We're sending you a request to unmute your microphone.
Thank you, Ben Caldwell, MFT. I just want to renew the request from earlier today to have someone from ASWB's testing program come to talk specifically with the board and stakeholders about the recent changes in their process and any steps they may have taken to ensure measurement equivalency before taking those steps. The pass rate on the ASWB clinical exam is deeply problematic, and it suggests potential validity concerns with the exam itself. Thank you.
Thank you, Ben.
Chris, I do have one too after they're done.
Okay, we'll come back to you guys.
That was our only request via WebEx.
All right, Abigail.
So this is for our future agenda items, correct?
Yes.
Okay. Addressing a comment that I heard yesterday from a stakeholder, talking more about the DACA therapist and pathways for licensure, right? And access to building their hours, right, inside of agencies where they can be paid, right, appropriately for those hours. I think that that would help so much inside of our state with high risk areas and, you know, the Latino Spanish speaking population. So I think that that's, you know, a group that we've been ignoring that could really help solve a lot of the issues that we're having. Okay.
Thank you, Abigail. John.
And then also looking at something we talked about earlier about the ratio between the number of stakeholders moving through the system and the number of supervisors that are actually qualified and available. I'd like to consider looking at creating some type of program that is for the development of more supervisors within our stakeholder range. Because finding a qualified supervisor is definitely a speed bump for a lot of associates that are moving through the process. And so perhaps that's another way to expedite the process of moving towards licensure.
Thank you. Anything else? All right, perfect. And next item on the agenda is public comment for items not on the agenda. I'll now open for public comments for items that are not on the agenda. As a reminder, the board may not discuss or take action on any matter raised during the public comment section, except to decide whether to place the matter on the agenda of a future meeting. Each commenter will have 2 minutes. Do any of the board members have comments for items that are not on the agenda? Kelly?
I understand that this is Board Member Ortega's last board meeting. I'd like to thank her for all her service. I think the resolution was well worded, and we are going to deeply miss her comments. And that's it.
I second that motion. All in favor? Yes, you'll be very much missed. Abigail. Any further comments? John?
In my experience with this board, we've done an excellent job at really looking at all the facets of the multiple populations that live in the state of California. And I would like to encourage us to continue with our efforts to not do DEIA, but to do diversity, equity, inclusion, and accessibility. The phrase DEI has become a buzzword that's very popular right now. And I would like to encourage us as a board to really look at the words that make up this acronym and to continue to use them as part of our touchstone as we're developing programs and doing legislation as we move forward.
Thank you, John. All right. Any further comments? Comments from our in-house participant? Nope. Justin, I don't mean to ignore you. Oh, you put your hand up. You're good? All right. Any comments from our online participants?
We are open for public comment via WebEx for agenda item 36, public comments for items not on the agenda. If you'd like to make a comment, please raise a hand by tapping that hand button at the bottom of the screen. Mobile device users, you may need to hit the ellipses button, that's the ... in order to find your hand. We're going to spend just a few more seconds to see if we have a request for public comment. Seeing no request for public comment, do you wish to continue?
I do. Thank you. And with that, my friends, we are at adjournment. I hope to see you all at the next board meeting that will be held on August 21st in Newport Beach. And with the last swing of the gavel, meeting is adjourned.
Thank
And I hand the gavel over to